Swayam Prabha. Digital India. Educated India.
Welcome viewers. I am Dr. Ashwini Sival from Faculty of Law, University of Delhi. I welcome you all to this lecture series on law, science and technology. Today's lecture is about privacy in digital age. It is lecture number 16. Well viewers, we know that after the advent of these sophisticated digital communication mediums and tools, we see that there is no privacy left, and nobody's privacy is safe, or you may say nobody has any private life, because we very well understand that something that is coming for free, then it means you are the product. What does it mean? This is a very strong statement, viewers. When these digital platforms, or for that matter digital technologies which are being made available to you for free, it means you are the product, you are the your data, you are the fuel for them, your personal information is fuel for them. And we all have been hearing that in this century data is the gold mine, and everything is basically data. Wars are being fought on the basis of data or on the basis of information. We all know that democracies are made and destroyed on the basis of the information sought or gathered. So it is very important for us to understand the digital age and the concept of privacy in the digital age. But to understand this, one needs to understand what does privacy mean, what are the different contours of the privacy, what the Constitution of India talks about the privacy, what the laws in India talks about the privacy, how one's privacy has been protected or is ensured a protection or guaranteed a protection in India. Is it really guaranteed? Is it really ensured? Or there does not lie any assurance on the privacy, because we are living in the digital age, which is a brink situation where we don't know where our information is stored and processed, or where we don't know how it is manipulated or maneuvered, to what extent that information is maneuvered or manipulated, and in what context it is maneuvered and manipulated. So to understand these and the niceties relating or surrounding this important aspect, I am here today with you to talk about it. In my today's topic, I shall cover the following things which are on screen. We will talk about the concept of privacy. We will talk about right to privacy, which is a fundamental right now. We will talk why it matters. Is it really important? What is the impact of digital age, which is enormous, and how can disruptive technologies of the present day can affect our privacy? What are the issues and challenges posed by the technologies vis-a-vis privacy, policy issues and solutions thereto, and we will have a look at some relevant judgments, Indian as well as foreign, and some relevant statutes, and then finally the conclusion. These are the things which I am going to cover today in my today's talk, dear viewers. So let us begin with the introduction to the concept of privacy. Well, with the digital age, the possibility to introduce in someone's private space has phenomenally increased, and it has happened due to the development of science and technology. The same science and technology facilitates us in myriad ways in different dimensions, but the same sometimes is detrimental to us or to our privacy. The laws are reactionary or has always been reactionary So, with the advancement in the digital or with the advancement in the technological tools, the laws have also reacted, and to protect and ensure the or guarantee our privacy, some new laws has been brought ensuring legal protection of privacy. However, in order to ensure privacy, first of all it is necessary to determine the subject of protection as to what is privacy and what actually the privacy is. This becomes all the more important, because unless you know it, you understand its nuances, its contours, you can't tell what is to be protected, what actually is to be guaranteed and ensured. Well, this concept of privacy dates back to old ages. It is as old as mankind. It was not a legally protected right in ancient times, viewers. However, privacy protection is the need of the hour today in the age of rapid technological development of the information society. Why it has become more important nowadays? Because of the newer ways of impeding into your private sphere. You never know how one will view your private life, how one will use your personal movements. You never know how one will use your sensitive information. So, that is why this old concept has become more important and topic of debate today and more relevant today. Privacy is closely connected with human dignity, freedom, independence of an individual. Now, coming to the contours of privacy, viewers, it is your dignity, it is your freedom, it is independence of an individual. What is considered to be private is contemporaneous with different times and according to different era. What now is private may not have been or was private in the ancient times, or may not be private in the years to come. So, it is something which is contemporaneous. You have to check your individual freedom and privacy or its contours according to the contemporaneous situation, according to the present social mores and current cultural and social mores. Everything which is considered private need not be legally protected. This is also true that everything which is considered private is not required to be protected, but those aspects, those particularly those important aspects of your individual freedom, your liberty, yourself are to be protected, which does not cause any harm to law and order, which does not threaten the security of the nation, which does not impede into someone else's life. They are to be respected and protected. So, privacy is not something which can be categorically defined in one unilateral meaning or dimension. It is something which is multilateral or multidimensional. It is something which may not be defined in a straightjacket way or in a straightforward way, but it is still required to be understood. It encompasses your liberty, your individual expression, your own life, your own personal sphere. The idea of privacy comes from the difference between private and public, the natural need of the person to make distinction between himself and the outer world. Now, let us go to the historical development of the notion of privacy to understand more what privacy actually is. The modern privacy notion provided by Louis Brandeis and Samuel Warren in The Right to Privacy, published in Harvard Law Review in 1890. The authors defined this right to be let alone. This is the kind of definition they gave to the concept of privacy. Right to be let alone. Protection against unwanted disclosure of private facts, thoughts and emotions. Privacy does not only mean that your physical privacy, it is emotional too. It is privacy, or it is exclusivity to your thoughts, to yourself, or right to be let alone in all ways, holistically, not only in the physical sense. Possibility of self-determination was limited as private lives were strongly influenced by the state in the ancient societies. But now the private lives are not so strongly influenced by the society or by the state. Further, Plato in his works illustrated the phenomenon where complete life of the individual was determined by the state and its aims. There was no place for individual freedom and autonomy. This was the time when everything was controlled by the state, everything was determined by the state. Nobody has his or her individual freedom or individual privacy or liberty. Everything was completely into the control, full control of the state. In medieval societies too, the situation was not very congenial vis-a-vis to the privacy protection, as subjects were under constant and continuous monitoring. But things changed gradually. Today, when we are living in this progressive society where we have our individual rights, we have our ownership rights, we have our fundamental rights, so we have our privacy and the right on privacy, or you may say fundamental right on privacy. The notion of privacy branched out into physical and mental privacy, and both these branches evolved separately. So the privacy, as I said earlier, is not just physical, it is mental too. Your thoughts, your expression, everything is related to your privacy, and it is to be respected by the state as well as by the other individuals of the state. Social, economic and political changes and technological development evolved and developed the concept into that of fundamental human right. Now privacy has become a fundamental human right because of the social, economic and political changes which happened over the period of time. Understand privacy in terms of knowledge, dignity and freedom. So today we understand privacy in terms of knowledge, dignity and freedom. These are the three important components in the context of which in today's world we understand the concept of privacy, which have been earmarked here: knowledge, dignity and freedom. If we go further and see definition of privacy, so as I said that no universal definition despite several attempts, not possible to have a one singular definition. Comprehensively it can be defined as the right of an individual to decide about himself or herself. The claim for privacy is universal, however its concrete form differs according to the prevailing societal characteristics, the economic and cultural environment. Therefore privacy must be reinterpreted in the light of current era and be examined in the current context, right? Alignment with the prevailing circumstances and the cultural and social mores. Three levels that affect privacy. Now this is very important, viewers: political, socio-cultural and personal. These are the three levels that affect your privacy to the most. So your privacy revolves around these three important levels or three important factors: political, social, cultural and personal, right? Privacy is understood as an aura around the individual, and the contours of this aura change from context to context, individual to individual. The quest is to balance this contextual and individualized aura and create a standard which can be protected. But this quest can never be complete because social and contemporary mores of the society, cultural values of the society, political environment in the country as well as personal sphere will keep on changing. It will never remain static. So is your privacy. So the definition of privacy can never be straightforward. It is dynamic, it is not static. It will keep on evolving and changing with the period of time, with the circumstances. There are certain elements which we may refer to understand the concept of privacy. Let us have a look at all these elements one by one. The right to be let alone, limited access to the self, secrecy, control of personal information, personhood, intimacy, and these six things together, if taken together, give us the backdrop or give us the idea of privacy. These elements constitute the idea of privacy. Your secrecy, personhood, intimacy, control of personal information, right to be let alone, limited access to the self. These are some aspects of privacy which are very important. Richard Posner once said that one aspect of privacy is the withholding of concealment of information. The claim of an individual to determine what information about himself or herself should be known to others. It is you who will decide what information about you shall be known to others. Nobody can take away your right, and nobody can spread anything about you or can talk about you unless you choose to do so. So this is something that is called private. But this is not, again I said, based on one single thing. It is based on several things. American professor Tom Garrett understands privacy as the control over or the autonomy of the intimacies of personal identity. Privacy can be interpreted in different ways, and there are many aspects of privacy that exist. As all these definitions state something very important about what we should consider private, it is an extremely hard task to attempt to create a uniform definition of privacy. So all the scholars of this field have agreed uniformly that there can be no definition of privacy which can be called a complete definition. Why it matters? Now coming to the next stage, what is privacy we have already understood, but why it matters, why we are so concerned about our privacy, what is so problematic if our privacy is snatched away from us, what is so problematic if state takes the control over our privacy. Well, it matters because state must not take over our privacy. It is something that is individual. State must not interfere unless it is imperative for the state to do so. I am not saying that there should be a concept of absolute freedom or absolute privacy, but only in the emergent situations or exigent situations like law and order, security of the state, or so on and so forth, the state must intervene into your privacy. Otherwise, the state must not intervene into your privacy, or no other individual should intervene into your privacy unless you want to do so or agree to do so. Well, this aspect, why privacy matters, can more beautifully be understood by referring to the following points as listed out here. Importance of privacy can be understood under three broad heads: benefits to the individual, benefits to personal relationships, benefits to society. The degradation of consumer data privacy in the digital environment causes objective detriment to consumers and undermines the competitive process, and it leads to criminal activity, discrimination, exclusion, manipulation, humiliation, competition law concerns, bargaining power. What happens when you lose your privacy? What happens in a country like India when somebody who is not supposed to know beyond your personal character or person or yourself, when he knows about your particular race or a particular sect or a particular caste, it leads to what? Discrimination, exclusion, manipulation, humiliation, and in the marketplace sometimes competition law concerns arise, and criminal activities also do occur because your life is not private anymore. What is the impact of digital age on it? Well, digital age has facilitated us in many ways, but it has also caused equal hazard or detriment to our lives by making it more easier for anyone to surveil on you, by making it more easier for anyone to impede into your private sphere, by making it easier for anyone to know about your sensitive information, even your biometric information, even your iris information, even your demographic information, which ideally nobody is supposed to know. So we all know that Big Brother is watching, and nobody in the world is technically private. Nothing technically is private. Everything is being watched, is surveilled, especially in the digital age. When we are using the digital equipments, we are available digitally. Our entire information is available digitally. Everything we share online is going to different hands or changing different boundaries, transcending borders, and we don't know how our information is processed, and we are no more private. Our photographs are being morphed, our identities are stolen, our personal information is compromised with. So nothing is private. The technological change that the world has seen can be compared to industrial revolution. Three facets of digital revolution which may be compared with the industrial revolution: increase in data creation, data is the new oil, as I said in the beginning. Then globalized data market, increased ability to collate and examine data. We all know about big data, how data is mined and processed. Then lack of control mechanism for digital data. No control mechanism or regulatory framework is there, or if there are any regulatory frameworks, they are not adequate enough to control or process your digital data in a adequate manner or in a sophisticated manner, so that it does not get compromised. Increased ability to manipulate the data generated onto overwhelming recording of every interaction with the internet. So whatever we do, even on social media platforms, on our emails, on our e-commerce websites, or otherwise for that matter, even during normal transactions in the marketplace, if we suppose buy something and make a digital payment, or if we go to a marketplace or make a payment via credit card, our information goes, it no more remains private. So it has become more vulnerable to manipulation, and this ability of manipulation has increased tremendously because of overwhelming recording of every information about yourself in the digital medium. All the data recorded can be transmitted and sold with a click of button over the globe. We have heard that, and we keep on hearing through news channels, in print media as well as electronic media, that millions of users' data is being sold or was sold at a very nominal cost. Over the globe, it may be sold, which leads to what? Further criminal activities against the users or the consumers. Newly commoditized information market. We all know that today's market is newly commoditized, and it is an information market where collation and manipulation and profiling is very easy. Limited ability of consumers to control the information and manipulation, and digital age affects every aspect of privacy. So in nutshell, I will say that digital age has very huge impact on your privacy. But how would you reconcile with it? What will you do? What the state has done, what the laws have done? Let us have a look. We have understood by now what is the privacy and what the privacy mean. We have understood the evolution of the principle of privacy. We have understood the impact of digital age on privacy. Now moving forward, let us have a look at some of the problems which are occurring because of the digital age. Financial gains or public records are being manipulated, medical and health data is compromised, and privacy in the digital age is no more intact. It is vulnerable to new frontier technologies, right? So privacy in digital age basically is something which you want or you desire to have a control or some influence over your data or about yourself in the digital medium. It includes your personal communication and personal data in the digital space. But advances in IT has raised concerns about information privacy. Four major concerns in information age are basically privacy, accuracy, property and accessibility. What are the legal instruments? We have understood all the challenges and several important concerns in the digital age because of the impact of the digital age on the privacy. But what are the legal instruments that are available to us to have some robust framework to stop the infringement of our privacy or encroachment or intrusion to our privacy? So starting from the United Nations, some of the important legal instruments that I have jotted down here for your perusal. First is the Article 12 of the Universal Declaration of Human Rights, which emphasizes on the privacy of a person and it says or reads that it is your human right to hold your private information intact. It is your human right, it is the essence of this particular article, it is your human right to have your private life intact, or not to be let alone to be used or to be compromised by others. Then we have Article 17 of the International Covenant on Civil and Political Rights of United Nations, again of 1966. Then we have Article 8 of the European Convention of Human Rights, Council of Europe of 1950, and Article 7 of Charter of Fundamental Rights of the European Union. United Nations Convention on Migrant Workers, Article 14, UN Convention of the Protection of Child, Article 16, International Covenant on Civil and Political Rights, International Covenant on Civil and Political Rights, Article 17. Moreover, this is important than the previous ones, we have regional conventions including Article 10 of African Charter on the Rights and Welfare of the Child, Article 11 of the American Convention of Human Rights, Article 4 of the African Union Principles on Freedom of Expression, and more such things which are written on the screen. What does it signify? All of these, all of these. This signifies that we have enough instruments, adequate provisions to tackle the intrusion to our privacy. But yet we see that there is no such thing that keeps our things private. Our nation states encroaching into our privacy and violating the norms as set out through these legal instruments, or is it allowed to the nation states to intrude into your private sphere and take away your information or surveil on you irrespective of these legal instruments? This is the question that we need to deliberate on, or we need to ponder over. Well, viewers, as I said in the beginning, at the outset, that no absolute right is available. In fact, I will say that in the ancient times there was no concept of individual rights or privacy at all. Everything was under the control of the state. But these days we have understood or realized our rights. In fact, our rights are being upholded and protected by the courts of law as well as by the political parties. But when it comes to some aspects, it is not an absolute right, and it is something that a nation state may intrude into. But what are those situations when the nation state may intrude into your private life? When is it allowed for a nation or for a state to surveil on you? What are those situations and circumstances? Let us have a look at all those one by one in the ensuing slides. Following some more legal instruments in the Indian context, this is on Indian context. We have Indian Telegraph Act, we have IT Act, specifically 43A of the IT Act, and rules pertaining to rules of 2011 pertaining to 43A. Then we have CRPC, section 91 and 92 of the Code of Criminal Procedure. Then we have Indian Constitution, specifically Article 21 and Article 19(1)(a). These two provisions are, you may say, the backdrop, or you may say they are the grand norm for providing you the right of privacy or fundamental right of privacy as recognized by the Indian courts in some of the cases in India, which we will discuss shortly. We have another important act, that is Digital Personal Data Protection Act of 2023, which also provides a mechanism for protection of your personal data and personal information. And this is a latest act of 2023, my dear viewers. So let us talk about this act first, its objectives and its contours, and what all it covers and what all it does not cover. So far as this act is concerned, it is first ever privacy act to strike a delicate balance. Well, talk about bringing a digital act or digital data protection act or a data protection act in India started way back in year 2006, but it miserably failed time and again. In 2011 also they brought the bill, in 2018 also they brought a bill, but finally we have got this act in 2023, that is called Digital Personal Data Protection Act of 2023, and it is first ever privacy act to strike a delicate balance between individual rights and an organization's legitimate data protection processing needs. Not data protection, sorry, data processing needs. Well, it has this act has been enacted on a very, very strong foundation, because the idea here is to strike a delicate balance between what? Between individual right on the one hand and an organization's legitimate data protection needs on the other hand. Because it is not possible for you to operate or live peacefully in these days without using social media platforms, without doing some digital payments or interactions, etc., or communications, etc., digitally, and your information over there is processed. So this act has stricken a perfect balance as to how to maintain or uphold the individual right on the one hand and the organization's legitimate right of data processing on the other hand. Well, the primary purpose of the act is to regulate the processing of digital personal data and respect individuals' right to protect their data while recognizing the necessity of processing and using such data for lawful purposes. Well, this is to be noted, viewers, that for lawful purposes your data may be processed and used. This is what I called that that the state has certain rights over your private information. You don't have absolute right. What kind of rights state has? For the lawful purposes, state may process and use your data. The language employed in the act is simple and straightforward, ensuring easy comprehension for all. Moreover, the act aims to establish a comprehensive legal framework to govern digital personal data protection in India. The act's provisions cover personal data in digital format, including both data that originates digitally and non-digital data. This is again very important aspect of this law and noticeable aspect of this law, that it protects both data that originates digitally and non-digital data that is subsequently digitized. What is non-digital data? You go to a marketplace, your behavior is being observed and noted in a supermarket. What you buy, in what particular month you buy, which particular grocery, which particular clothes you like, and that information is digitized by them in order to strategize about the market consumer behavior, right? So even that is included in this particular act, or it caters to even non-digital data which is subsequently digitized. It just not only caters to or addresses the data which originates digitally originally, rather on a data which is non-digital but subsequently it is digitized. The provision applies to data processing within and outside India. Another striking feature of this law is that this law applies to data processed within and outside India. Within and outside India. If it relates to the offering of goods or services to individuals within India, the rider is that any multinational company which is having a business in India, and if they are offering goods or services to individuals of India, then this law will be applicable on them, even they are outside India or they are not having any existence in India physically, or you may say they don't have any particular business office established in India, because they are offering the products to Indian consumers, and if they are trying to take away your data and try to process it outside India, this law will be applicable. It even caters to that. So these are the striking features about this act. The act further provides for the processing of digital personal data in a manner that recognizes both the rights of the individuals to protect their personal data and the need to process such personal data. Now coming to personal data, again a very important feature of this act, that it also recognizes the protection of the personal data and the need of processing of such personal data for lawful purposes and for matters connected therewith or incidental thereto. The Act protects digital personal data by providing for the following. How it protects your digital personal data? The mechanism has been provided. The obligation of data fiduciaries for data processing are clearly put there. The rights and duties of data principals and financial penalties for breach of rights, duties and obligations are categorically or explicitly provided therein. Well, who are data principals? Data principals are those people who take your data, right? And you may be also called a data subject. Your data is being taken away by them, so you are a data subject. But here some rights and duties, right, have been clearly explicitly written and categorized. Similarly, rights and duties and obligations of fiduciaries have been clearly written and described, and financial penalties in case of breach and obligations and duties have been clearly written and explicitly described. The Act also seeks to achieve the following. It introduced data protection law with minimum disruption while ensuring necessary change in the way data fiduciaries process data. Data fiduciaries, as I explained, are persons or companies and government entities who process your data, right? So there are provisions in the law which are categorically defining minimum standards for them or obligations for them to follow or compliances for them to follow, so that there should not occur a breach into the private person's privacy or his or her personal information. So that this Act achieved the following by enhancing the ease of living and ease of doing business and enable India's digital economy and its innovation ecosystem, right? Now this Act is also based on the following 7 principles which are important for you to look at. The principle of consent, lawful and transparent use of personal data. Well, no person's private information can be processed or used or taken away from India unless he consent to the same. And how this consent is taken? This consent is taken when you subscribe to something. In the terms and conditions, they describe their terms very well, and you are supposed to read. So sometimes you give a consent by a mere click without even having read the particular terms and conditions, but once you have clicked it, it means you have agreed to it. So the principle of consent, lawful and transparent use of personal data, the principle of purposeful limitation, right? Use of personal data only for the purposes specified at the time of obtaining consent. No entity, no government, no multinational company is allowed to use your personal data beyond the stipulated agreed terms and conditions. If they have taken your consent to process your data for strategy making, etc., they can do so. But if they start processing it for some other purpose, then they are violating it. It is clearly written that their purpose is limited or has been categorically defined. Then the principle of data minimization. Here the Act again beautifully based on a very important principle, that collection of data is allowed only when it is emergently required, or only as much personal data as is necessary to serve the specified purpose, not beyond that. So the principle of data minimization is again another important feature of this law. The principle of data accuracy, ensuring data is correct and updated. The principle of storage limitation, storing data only till it is needed for the specified purpose and then deleting it, not to keep it forever with the organization. The principle of reasonable security safeguards, and the principle of accountability through adjudication of data breaches and breaches of the provisions of the bill and imposition of penalties for the breaches. Well, these are 7 key important principles which make this law very powerful in the context of your privacy, especially personal data of yours, which is to be minimized, which is to be stored in a limited way, which is to be kept secure by putting some safeguards, etc., right? The Act has few other innovative features. The Act is concise and thorough. that is simple, accessible, rational and actionable law. Well, this is very important for you to see and to have a look at. It is SARL. SARL stands for simple, accessible, rational and actionable law, as it uses plain language, it contains illustrations that make the meaning clear, that contains no provisions or proviso and has minimal cross referencing. Another striking feature about the law is which is a rarity in the Indian context, because our laws usually are based on the colonial language or on the basis of colonial style. But now in 2023 this law has been made in a very simplistic fashion so that commoners can understand, because at the end of the day it pertains to commoners and their their personal information as well as their privacy. So it is a SARL law which contains illustrations, which has no provisos, which has minimal cross references. Now going to another important aspects of this law which makes it gender neutral, right, which makes it gender neutral. Here the word she instead of he has been used for the first time in any law in the country. Our laws usually uses the term he, him. Our laws never used she, her, but here the law has used the she instead of he for the first time and acknowledged women in parliamentary law making. The Act also provides for following rights to the individuals: the right to access information about person data process, the right to correction and erasure of data. Well, this is very important. It is equivalent to right to be forgotten. Some case started against you some years ago which was a false case, or it turned out to be what, a case filed by somebody with the malicious intent, and you have come out scot free, you have been acquitted by the court of law. But in the digital sphere your information about the particular or accusation about a particular event is yet lying there. So this is a law which allows the erasure of data, it allows the right to be forgotten, right to grievance redressal, it allows the right to nominate a person to exercise rights in case of death or incapacity. So in case some information of yours is lying there and you didn't bother, but it is harming your legal heirs, it is harming your family, so those persons whom you nominate, or in case of death your legal heirs, can also get it eradicated, they can also get it erased. This is again very important feature of the law. It is very tough for anyone to get the data erased from the virtual space about you. Even if you delete your social media platform today, and if you want to retrieve, it may be retrieved from where you left, or any information which is available against you, maligning you, causing a derogatory remarks about you, will still be available there, but this allows erasure of the data. For enforcing someone's right, an affected data principal may approach the data fiduciary in the first instance. In case he or she is not satisfied, he or she can complain against the data fiduciary to the Data Protection Board in the hassle-free manner. So we have a data protection board under this law, and one can first exhaust by contacting the data fiduciary. If the data fiduciary does not act, then you may contact the Data Protection Board, and in a hassle-free manner you may get your concern addressed through the Data Protection Board. Now coming to some obligations on the data fiduciaries which are there in this law. This law reads that the data fiduciaries have to be obligated, and they have to take care of someone's personal data, to intimate personal data breaches to the affected data principal and the Data Protection Board. There are provisions to erase personal data, etc., which I have already explained, so I will skip the slides. The Act safeguard the personal data of children also. Again a very important feature, that children which are a more vulnerable group, they are a more vulnerable group or a susceptible group, so it allows personal data of children also, safeguards of personal data of children also. We know that the teenagers and very small children these days are using the social media platforms, and they are available virtually, and they are having their digital footprints or imprints. So their personal data and their personal information is also very important to be taken care of. So in that case, the law allows the data fiduciaries to take away the children personal information only with the consent of the parent of the children. Unless he turns 18, the children data may not be used without the parental consent. The act does not permit processing which is detrimental to well-being of children or involves their tracking, behavioral monitoring or targeting advertising. This is again very important, that anything which is detrimental to well-being of children or involves the tracking of the children or their behavioral monitoring or targeted advertising, the act does not permit the processing of the data of the children to do these following stipulated things, right. Now coming to exemptions provided in the act, the law has certain exemptions which I told the states, the states rights or states right to interfere into your privacy. So for notified agencies, in the interest of security, sovereignty, public order, etc., there are exemptions. Notified agency like police investigation agencies may, in the interest of security, etc., or in the interest of public order, etc., they may intrude into your privacy or may use your personal information. For research, archiving or statistical purposes, your personal information may be used. For startup or other notified categories of data fiduciaries, there are certain exemptions. There are exemptions to enforce legal rights and claims, to perform judicial or regulatory functions, to prevent, detect, investigate or prosecute offences, to process in India personal data of non-residents under foreign contract, or for approved merger, demerger, etc., there are certain exemptions. To locate defaulters and their financial assets, there are certain exemptions. In these cases, as highlighted on your screen, some exemptions are available to the data fiduciaries, otherwise no data fiduciary has the right to intrude into your private information. What are the issues and challenges? Well, in the digital age, personal data and sensitive personal data, these two important aspects, they are very vulnerable, and the challenges are basically stemming from these particular two aspects. Then we have deep fakes, identity theft, etc., which are again challenges. Well, there are some more challenges which we need to look at, like privacy invasive technological services have become integral to everyday communications. So when we do use such services or avail such services, like technological services of finding jobs, consumption of certain things, some new search engines are so advanced, we take our private information, which are invasive technologies basically, right. So they pose lot of challenges in order to keep our data intact, or they pose several challenges to our personal information. So is the case of social media services as well as new search engines like social networks, e-commerce websites, where not so very privacy conscious consumers are using those platforms. People are just sharing their information without giving a thought or iota of thought about it, and later on they see that some wrong has been committed against them or some cyber crime has been committed against them. And lack of awareness and technical sophistication, as I told you that digital literacy is missing, right. Digital literacy is different than normal literacy, so technical sophistication is lacking, and there are multiple dimensions of your personal information which you are supposed to keep intact or to keep to yourself, but people don't do that because they don't understand, because they are not literate enough. Now let us come to the legislative part and the judgment part. As I told you in the beginning, that in this lecture we will see why privacy matters, what privacy is all about, we will see what are the legislative responses and what are the judge made laws and judgments pertaining to privacy. So as I told you that from the second part of 20th century, several international legal documents acknowledge the right to privacy as a first generation fundamental human right. Thereafter privacy protection appeared in the national legislations of the countries. The documents do not give further guidance on what privacy is. It is the case laws of courts which define privacy or which are safeguarding these regulations, right, in exact content of privacy and the aspects of life which can be considered private. So laws did not tell us what privacy is, what will be the contours of privacy, but judge made laws, or you may say the judgments or the courts basically in the cases provided different definitions and exact content of the privacy, right. So what are the important judgments that we are supposed to have a look at in the case of digital context, because we are talking about privacy in the digital age? We have a case cited or titled Karmanya Singh Sareen versus Union of India, which is also known as WhatsApp privacy policy case. Here what happened? In this case, validity of the WhatsApp's new privacy policy was challenged at the Delhi High Court. It was argued that the policy violated the right to privacy guaranteed by the Constitution of India due to impending Digital Personal Data Protection Bill, which was to be tabled in the Parliament. Soon then the case was adjourned. It is pending before the Honorable Supreme Court of India now. But we have now got our Digital Data Protection Act of 2023, and this case is yet to be decided by the Supreme Court of the country. And here, as I told you, that WhatsApp's new privacy policy was challenged in the court of law, where WhatsApp decided in its terms and conditions to have access to your communication done by you on the WhatsApp. Otherwise, WhatsApp is a encrypted messaging service. But what did they do? What change did they make into their terms and conditions? That anytime your personal communication may be accessed, may be seen, even the originator of the particular content may be traced, or originator's traceability provisions or terms were brought by the WhatsApp. So in that context, the Delhi High Court was approached by some groups, and it was argued that this particular thing violates the privacy guaranteed by the Constitution of India, but the case remained pending, and in the meantime we have got our Digital Data Protection Act. Then we have another case, not of India but of other countries, of another country, of European Court of Justice, on the right to be forgotten. Google Spain SL versus Agencia. In this case, the court reiterated that the operation of loading personal data on an internet page was considered as processing of data. The data found, indexed and stored by search engines and then made available to the users included information relating to natural persons and constituted personal data. The court further held that given the sensitive nature of the personal data involved and the fact that the initial publication had taken place 16 years ago, in this case, the data subject had the right to ensure that the information was no longer linked to their name. This is what I was discussing, that right to be forgotten has also been recognized in a different terminology by our law of Digital Data Protection Act of 2023, erasure of data, right. But here in this case, the European Court of Justice upheld the right to be forgotten, and accordingly there did not appear to be any preponderant interest of the data user or search engine, and it was for the national interest to determine on facts if the data subject could require the links to be removed. So it is the data subject who may decide whether he wants his information to be continued on a particular search engine or a platform, or he wants it to be discontinued, and that is to be determined by a court. The person has to reach out to the court, and the court will decide on facts whether a particular data subject is allowed to get his information erased or forgotten or not, because sometimes through these search engines, because they help also in finding the credibility of a particular person, a person whose information is available, or a criminal information or criminal footprints are available, may easily be identified by investigating agencies as well as by individuals. But if he will get his information deleted or erased, then nobody will know about him or his credence, so that is also important. We have another landmark judgment, or it is a watershed movement in the Indian context when K.S. Puttaswamy versus Union of India was decided by the Supreme Court, and the 9-judge bench, a constitutional bench in this case, unanimously affirmed that the right to privacy is a fundamental right under the Constitution of India. The court held that prior to this case, the right to privacy was not a fundamental right, but this court read it into the realm of Article 21 of the Constitution of India as a fundamental right. The court held that right to privacy was integral to freedoms guaranteed across fundamental rights and was an intrinsic aspect of dignity, autonomy and liberty. It was not a narrow right against physical invasion or a derivative right under Article 21, but one that covered the body and mind, including decisions, choices, information and freedom. So these are the definitions which we referred in the beginning, that privacy is not just physical, it is mental, emotional as well as informational. Privacy was held to be an overarching right of Part 3 of the Constitution, which was enforceable and multifaceted. Right? Significantly, while holding that right as an absolute in nature, the judgment also gave an overview of the standard of judicial review that must be applied in cases of intrusion by the state in the privacy of an individual. It held that the right to privacy may be restricted where such invasion meets the threefold requirement. The state has been allowed to intervene into your privacy or intrude into your privacy only in the cases of three following situations: legality, which postulates the existence of law. When any law made by the parliament allows any state agency to intrude into your privacy, the state may do so. When the need defined in terms of legitimate state aim is allowing it, then your privacy may be intruded into. Proportionality, which ensures a rational nexus between the objects and the means adopted to achieve them. Well, this is again very important. The court will decide what is the rational nexus between the object to be achieved and the means adopted to achieve them. So these are some of the important aspects. Now I am coming to the conclusion and the way forward quickly. Well, diverse combinations of regulatory interventions, technological solutions and economic incentives could ensure the balancing of protection and sharing that increase individual and societal welfare. It is abundantly evident that protection of personal privacy is rapidly emerging as one of the most significant public policy issues, and research on the economics of privacy will therefore continue to expand and evolve in coming years. Flexible interpretation of privacy, understanding the concept in a broader sense. Then privacy infringements caused by private entities or businesses shall be regulated, emphasizing the responsibility of the individual by educating them or raising their awareness level. One should have to be his own privacy commissioner and be aware, and educating people on basic informatics with respect to new frontier technologies specifically in the digital age. When the new technologies are brought and introduced to the public, they are supposed to be taught about the new frontier technologies, or at least basic informatics of those technologies. And consumers should be aware of the extent to which their personal data is collected and disclosed and the purposes for which it is used. Firms collecting data shall not understate and obscure their actual data practices. They must disclose what are their data practices. Comprehensive law for regulating collection of data, preservation, monitoring, intercepting, obtaining, analyzing, utilizing and retaining data is required and is there now with the Digital Data Protection Act of 2023, and I believe this law, along with the judge made law after few years or over the next few years, on the basis of this law, will definitely give us a comprehensive regulatory framework to take care of your privacy in the digital space. So thank you very much. I take your leave and looking forward to meeting you again. Thank you.